today, the United States Supreme Court decided the Fisher case that had to do with affirmative action and equal protection. They were asked to rule that, in fact, affirmative action violated the Equal Protection Clause, and they did not do that. They basically decided to reverse and vacate the case, send it back down to the Fifth Circuit to apply a standard that had already been upheld in 2003 in the Grutter case. I think there were a number of commentators who had anticipated we were going to get a case that said something along the lines of, with Justice Kennedy writing, that either affirmative action is unconstitutional, which this case does not say, or that it's still constitutionally permissible to seek to achieve a racially balanced class, but it's unconstitutional the way the University of Texas did it. And the case says neither of those two things. And so I think that from the perspective of people who are proponents of affirmative action, today was a very good day. Well, Abigail Fisher, her argument was that essentially that her equal protection rights have been violated. Essentially, the University of Texas uses, for most of the people who it's going to admit with respect to its undergrad, the top 10% plan. The top 10% plan means that if you graduate in the top 10% of your university or your high school class, then you are automatically admitted to a Texas undergraduate institution. For a smaller number of seats, the university uses race as a factor to determine who's going to be admitted. And she said with respect, she didn't graduate in the top 10% of her class, she's competing for the smaller number of seats, and she said that race was used in a way that violated her equal protection rights with respect to that other basket of seats. And so that was essentially the argument that she used below, and she lost in the Fifth Circuit. And so she had appealed all the way to the Supreme Court, and many people had expected the Supreme Court to rule in her favor. And so now we have to decide, well, what is the standard of review that a court should look at when trying to determine the constitutionality of an affirmative action plan that's been challenged because it's, the argument is that it violates equal protection. You had Justice Ginsburg, who was writing a dissent, basically said, I don't see any reason to vacate this case and remand it. I actually think that the Grutter standard was fulfilled by the Fifth Circuit. You had the rest of the justices, Justice Thomas essentially saying, I'm going to concur with this, but really I think all affirmative action plans are basically unconstitutional. But then you had Justice Kennedy writing for the court, with Chief Justice Roberts, Justice Alito, quite conservative, and then Justice Sotomayor and Justice Breyer adding in, saying that in fact the court below, the Fifth Circuit, had misapplied the Grutter standard. But the key thing to understand is that the Grutter standard is still the standard. It was the standard in 2003, it's still the standard today.